Hi, welcome to the Special Districts Association of Oregon Conference. It's a pleasure for us to be here. My name's Leonie Reeves, and I'm joined by my colleague Jess Osborne, and we're going to be talking about employee privacy inside and outside of the workplace. Because we're lawyers, we have to give sort of an obligatory disclaimer. A lot of the content we're going to be talking about today is very fact specific. We're going to be providing you general overviews and summaries of certain issues, but obviously you'll want to consult with an attorney if you are actually seeking legal advice. As I noted, my name's Leonie Reeves. I'm joined by my colleague Jess Osborne. We are with the firm Bullard Law. We're a boutique labor and management employment firm in Portland, and we advise public and private employers in all aspects of labor and employment. This is what we're going to be talking about today. We're going to provide an overview of the different sources of privacy and confidentiality rights. We're going to discuss, as employers, the obligations and limitations relating to privacy and confidentiality. And then we're going to use that overview to provide specific examples of how privacy and confidentiality rights might be applied in different contexts in the workplace. We will be taking questions throughout this presentation through the chat box. So rather than having and holding your questions to the end, please feel free to use the chat box to send us any questions. We will be answering them throughout the presentation. So let's get into it. Do public employees have a right to privacy in the workplace? Yes, no, maybe, or it depends. Well, like most lawyers, we're going to give you the maybe it depends answer. Again, a lot of what we're going to be talking today are very fact-specific inquiries. You're going to hear us talking a lot about balancing the government employer interests versus the employee's interests in privacy or in free speech when it comes to social media. But the sort of takeaway bottom line is that employees don't give up automatically or all of their privacy rights when they come to work. Employees indeed have an expectation of privacy when they come to work, and at times, some of those expectations are even reasonable. So to get us started, I'm going to sort of provide an overview of the law of what is privacy and what is a reasonable expectation of privacy in the workplace. And then we're going to get into some of the specific examples of how that might play out. So looking at the dictionary definition of privacy, what we're really talking about is 1B, the freedom from unauthorized intrusion by the employer, by you as a government employer, into an employee's affairs. And this is both in the office, so, unauthorized intrusion to your workspace, to your email, to your work cell phone, but also could apply to unauthorized intrusion outside of work. So what can an employer look at with respect to a personal cell phone or social media? So that's what we're going to be talking about, but we're not talking about an employee's right to keep things secret or those types of things. What we're really looking at, what is the limitation of your ability as the employer to intrude upon the privacy of your employees. How this plays out is, looking at the rules that limit how extensively an employer can do the following: search of an employee's possessions or their person, monitoring their actions, their speech, or their communications, whether that's their opening their mail or reviewing their text messages or emails. And then how much can an employer know about the personal lives of their employees, both inside and outside of the workplace? So for example, I just mentioned personal social media. How much can an employer know about an employee's personal social media? It could also apply to off-duty conduct or potential misconduct. How much can an employer inquire into an employee's activities outside of the workplace as the employer? So those are the types of things that we're going to talk about. There's lots of different examples of where employee privacy may be implicated. We're not going to talk about all of these, but we wanted to put up sort of a list of all of the ways in which this might come up. Everything from investigating employee misconduct, both on duty or off duty, monitoring the use of work email, internet, computers, phones, those types of things, monitoring of social media. We get so many questions about, an employer's ability to monitor employees' use of social media, office romances, who people can have relationships with, access to medical information and those types of things. So we are going to talk about quite a few of these areas, but not all of them as we go through today. So turning just to a brief sort of overview of some of the legal issues. So right now we're talking about employee privacy rights. And as I noted before on the slide with the dictionary, this is the freedom to be free from intrusion into personal or private matters. So this is how much can an employer intrude on an employee's privacy rights. Confidentiality, which we're also going to talk about, is slightly different, but a lot of times those terms are used interchangeably. But confidentiality typically refers to information about an employee or information that's been provided by an employee and whether or not that information is entitled to remain confidential, as opposed to the employer's right to inquire into certain information. So to give you sort of an example of the difference between privacy and confidentiality, whether or not an employer can inquire about certain medical information of yours, that would be a matter of privacy. It's can the employee intrude into your medical information in that way? Once the medical information is received, whether or not the employer can disclose those medical records or that type of medical information, that would be more a matter of confidentiality. The confidentiality that governs the employer's ability to provide, retain, or provide confidential medical information. And so again, those terms are going to be used interchangeably sometimes, and sometimes there's overlap. Both privacy and confidentiality will be implicated, but just wanted to sort of provide you a basic overview of what we're talking about when we're talking about privacy versus confidentiality. There are different sources of privacy rights, and some of these are going to be sources of both privacy and confidentiality, but some of the focus really here is going to be on the constitutional right to privacy. We're going to talk a lot about sort of the Fourth Amendment and, reasonable expectations of privacy as a constitutional right, but be aware that there are other types of laws, both federal and state privacy laws, that sort of carve out specific areas where employees have a right to privacy, or they have a right not to be intruded upon in certain areas or in certain ways. For example, the employment laws like the Americans with Disabilities Act has specific information about how you can't inquire or when you can inquire into certain medical information. There needs to be a certain sort of threshold that needs to be met before you can do that. So these are the types of laws that essentially say when you can't inquire into personal matters of your employees. We put employee handbooks, employer policies, and collective bargaining agreements here because an employer can be more protective of an employee's privacy than the law allows. So the employer could have a policy that, protects employee privacy and says that you're not going to infringe on employee privacy, even where legally you might be entitled to do that. That's part of what's going to be analyzed in looking at whether or not an employee has a reasonable expectation of privacy. If the employer has said, even if it's not required under the law, if the employer has said you have a reasonable expectation of privacy that we're not going to check your social media, or that we're not going to check your text messages, or that we're not going to monitor your email, you're going to probably be bound to that policy, even though under the law, you may have been able to do that. So you just want to make sure that in your employee handbooks, your policies, and collective bargaining agreements, you have a clear understanding of whether or not you are, basically representing to employees that they're going to have more protection than might be required under the law. As I said, the most sort of significant source of privacy rights is going to come from the Constitution. There are a number of amendments to the Constitution and also the Oregon Constitution that have been interpreted to provide employees privacy rights. We will just say that none of these provisions directly reference a right to privacy. It's been through interpretation and case law of these different rights that are guaranteed to people and to employees, especially public employees, when they work for the government. They've been interpreted to create different types of employee privacy rights, but none of them specifically say employees have a right to privacy. Most significant to sort of the topic of the day is the Fourth Amendment search and seizure clause. That amendment says that, there's a right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of themselves and or their property. We're going to be talking a lot today about what that unreasonable means because, as you can see from the text of the Constitution, it's not an outright prohibition on searches and seizures of selves or property. It's a prohibition on unreasonable searches and seizures. So what unreasonable means in any particular context is going to be really important. It's also important to sort of just understand the context that we're talking about this here at this conference because most, if not all of you, are public sector employees. The Fourth Amendment and, that protection, that freedom to be free from unreasonable searches and seizures is a freedom to be free from unreasonable searches and seizures by the government. And because you are the government as an employer, this particular amendment applies to you. Private employers, it is much more, they have much more latitude to intrude into the business and the affairs of their employees because they are not the government, and the Fourth Amendment does not apply to them in the same way it applies to you. So that's just an important thing to note, why it's so important that we're talking about it here. As I mentioned earlier, reasonableness is going to be sort of a touchstone of the analysis of whether or not the Fourth Amendment is violated. That is the touchstone of the Fourth Amendment. And in determining reasonableness, courts are going to look at the totality of the circumstances. And I mentioned earlier that a lot of what we're going to be talking about today are very fact-specific inquiries. That's why, we can't give you a bunch of blanket rules. This is allowed, this isn't allowed. We're going to give you sort of the framework of what courts have found to be reasonable in other contexts. But for each context, you're going to have to go through that analysis and looking at the reasonableness of a search by assessing, again, we're going to talk about that balancing, right? The individual's privacy on one hand and the government, your need to know as a government employer on the other. So that reasonableness, that fact-intensive, case-specific inquiry, and that balancing are all things that you're going to be hearing just sort of over and over today as we talk about how these different scenarios play out. I mentioned that there are some privacy protections that come from statute as opposed to the Constitution. I'm not going to go through all of these, but this is a list of some of them. So, for example, the Genetic Information Non-Discrimination Act says that you can't inquire into family medical history. So the federal legislature has carved out a right to privacy that employers don't get to ask employees about family medical stuff. As I mentioned earlier, the Americans with Disabilities Act, you can't make medical inquiries unless there are certain circumstances that are met, and that is that the inquiry is job-related and consistent with a business necessity. And so the federal statute, the federal legislature has carved out certain areas where employees have an expectation that you will not intrude at all or unless certain circumstances have been met. I'll take a minute to talk about, in Oregon, we have some common law privacy rights that also sort of implicate an employee's privacy. These are important just to understand because these allow sort of personal real damage remedies under state tort law that an employee might have against an employer. And Oregon courts have long recognized the right to privacy in employment. So, we do have that as a basis in Oregon common law. There are sort of 4 different types of invasion of privacy torts, and some apply to the employment setting better than others, but I'll go through them briefly. So the intrusion upon seclusion is a tort that says that you won't unreasonably invade into somebody's private affairs. An example of an intrusion upon seclusion might be if an employer or a business has a camera in a bathroom or in a dressing room or a locker room. That would be, by most standards, an unreasonable invasion into the private affairs of your employees. And so that might be a situation where the intrusion upon seclusion tort might be implicated. Public disclosure of private facts is when there are facts that are highly offensive to a reasonable person, where there's no public sort of interest in the right or the knowledge to need to know of private facts. So for example, if an employer publishes a press release that talks about the sexual affair between two employees, even if it's true, that might be found to be highly offensive to a reasonable person if there's no legitimate interest of the public to know that information. Now, there could be legitimate interest to know. So for example, if it's, public officials, elected officials, high-ranking officials, if it implicates, other ethics issues, there could be reasons that there were as a legitimate interest to the public to know that information. But essentially, the tort is to protect individuals, or in this case, employees, from employers basically disclosing to the public things that are extremely private in nature. The tort of placing an individual in a false light is a little bit different. This is publishing information that is false. So, for example, if an employer issues a press release that says X employee is swindling money from the company or is engaging in some kind of financial misconduct, if that has not been substantiated yet, or if that turns out that that is not a true allegation, then that is placing the individual in a false light. It sounds a lot like a defamation claim. They're similar, they're related, but this is more in sort of the privacy realm of the torts as opposed to the personal injury realm of torts. So, that would be sort of an example. If you publish false information about an employee, that might implicate placing an individual in a false light. And the last privacy-related tort is called right of publicity, and that's basically people or employees have a right to control their own name or likeness. So, for example, if the employer publishes a photograph of an employee at their workspace where they haven't given permission, and they use that for promotional materials, it says, "Hey, come work for us. Look at how happy this person looks at their desk," and that employee hasn't provided the consent or even notice that that is going to be published in that way, that could implicate the common law tort of right of publicity. Now, a caveat to all of these common law torts is that a defense to them is consent, or that the employee had no reasonable expectation of privacy. So if the employer can show that they were on notice that they were going to get recorded, or if they can show when we took a photograph of, John Smith sitting at his desk, we asked him to fill out a consent form that said, "You understand that these may be used for promotional materials." That would be a defense to the tort. If the camera's in the workplace, there's going to be very few scenarios where a camera in a bathroom or a locker room is going to be found to be reasonable. But if it's a camera in, the assembly line, or if it's a camera on the shop floor, the cameras are obvious, and even more would be even better practice is that there are signs posted, recording in progress, those types of things, then the employer can say that the employees didn't have a reasonable expectation of privacy. They were on notice that these cameras were recording, at least the video, not the sound, were recording, and that there was implied consent. So that's sort of the way that an employer can mitigate liability from some of these privacy-related torts. I'm going to turn it over to Jess now, who's going to walk us through some specific examples of workplace privacy.
Thanks, Leonie. Ending on a reasonable expectation of privacy is an excellent starting point for this section. So we're going to go through various examples of different types of searches or areas where workplace privacy can be implicated based on kind of the surrounding circumstances. It's going to be a fact-based inquiry, as we've been talking about. So just as a general starting point, employees may have an expectation of privacy in a variety of areas in the workplace, both in their physical spaces and in remote workspaces, as well as in their personal, in their person and their personal belongings. So we'll cover some of these areas in greater detail, but we'll be talking about the concept of searching workspaces and also personal searches, physical mail versus remote technologies or remote communication services, whether or not or how and when wiretapping and recording can happen, including video surveillance and GPS tracking, And then we'll switch over into discussion of social media, alcohol and drug testing, and then general workplace investigations. Next slide, please. So in looking at searches of workspaces, employers may have the right to conduct a search. So this might come up in investigatory context or a non-investigatory context. The concept is going to be really related to kind of a two-part look. It's going to be the particular circumstances surrounding the reason for the search, and then whether or not the employee has that expectation of privacy in the space or item that's being searched. Next slide, please. So the kind of keystone case in relation to physical workspace searches is a case that came out of the US Supreme Court in 1987 called O'Connor v. Ortega. Dr. Ortega was a public employee working at a hospital. And it was a case where the court, on a plurality decision, which is a non-majority, but gets to a place where there's a consensus, was looking at whether or not an employer's search of the workspace was appropriate. So hospital officials, as a way of background, had become concerned about possible improprieties in the management of Dr. Ortega's program, and it had a particular look at his acquisition of a computer and charges against him concerning sexual harassment of female hospital employees and taking inappropriate disciplinary action against a resident in his program. He was put on administrative leave during the pendency of the investigation, and during that time, the hospital officials went into his office and conducted a search and ended up seizing some personal items that were found in his desk and file cabinet specifically. And those were later used in an administrative proceeding against him that resulted in his discharge. Now, the hospital said that the purpose of going into his office in the first place was to take an inventory and to secure any state property that would be in there, which is a fairly, at least on the surface, reasonable purpose for the hospital to be in there. Following his discharge, Dr. Ortega ended up filing a lawsuit against the hospital and some of the hospital officials, and that proceeded up through the federal court system. And he alleged a Fourth Amendment violation in the search and seizure of his items. So in reaching its decision, the O'Connor court ended up establishing a two-part test that we'll get into a little bit later, but that's going to be the keystone of everything we talk about. And so the questions that the court looked at before it reached its decision was whether or not the warrantless search was reasonable under the Fourth Amendment, and then alternatively, adding to it whether or not Dr. Ortega had a reasonable expectation of privacy in his workspace, and whether he had a subjective expectation that the contents of his office and the circumstances that led to his suspension, if the contents of his office would be left undisturbed. And then whether or not that expectation objectively would be considered reasonable in society. And that's really the key piece that we're going to be looking at in any of these fact-based inquiry into whether or not a search is reasonable, is that objective standard. So you have the subjective standard of the individual employee, which can help inform the objective standard of the reasonable person in society. Next slide, please. So in looking at the circumstances relating to Dr. Ortega, the Supreme Court really dug into the considerations of a reasonable expectation, and looking at this situation specifically, go back to the employer arguing that the search was conducted for the purposes of conducting an inventory and to secure any property of the state. Now, Dr. Ortega himself had various factors that he put forth. First, the hospital had never instituted a similar search or surveillance of any employees similar to what happened to Dr. Ortega, and there was no policy in place for the hospital on whether or not offices or desks could be searched. Dr. Ortega had occupied that office for 17 years, and throughout the history of his time occupying the office, he had regularly kept personal effects and papers along with patient records and other workplace materials in the desk and office. It was his understanding that he was the only person who had a key to the office. And he was unaware of anyone ever entering his office previously without his permission. So he's establishing whether or not he had an expectation, I mean, of privacy, but also alternatively of the hospital even being interested in conducting such a search or having any history of conducting such a search. So the Supreme Court, in reviewing all of the factors and the background, stated that individuals do not lose their Fourth Amendment rights merely because they work for the government instead of a private employer, and held that public employees can have a reasonable expectation of privacy in their workplace. With Dr. Ortega, he had a reasonable expectation of privacy, and there was insufficient evidence to determine whether the hospital administrators had a legitimate work-related reason to enter and search the office. And taking a totality look at all the facts that they had in front of them on this case and the law as it stood, the court ended up remanding the case back down for the lower courts to engage in a balancing test between the expectation of privacy and reasonableness of the search for Dr. Ortega. Next slide, please. So there's limitations on privacy, obviously based on this reasonableness factor. And the courts have held, this is arising out of O'Connor v. Ortega, the courts have held that the public employer intrusions on the constitutionally protected privacy interests of governmental employees for non-investigatory work-related purposes, as well as for investigations of work-related misconduct, should be judged by the standard of reasonableness under all circumstances. So standard of reasonableness under all circumstances, I mean, functionally, the reality is that there's no one size, there's not a one size fits all approach to this. It's any search that is conducted by an employer has to be justified at its inception, and then it has to be reasonably related in scope to the circumstances which justify the interference in the first place. So the reasonableness of a scope of a search and the circumstances that justify the interference in the first place are also going to be informed by the workplace realities in the physical space or in the remote space. And the courts aren't going to be able to take a sort of like rubber stamping approach to a set of factors and then just automatically make a determination based on the same inquiry every time. It's going to be a fact-specific, case-by-case inquiry, because the reasonableness of an employee in a workplace that is open to everyone, is maybe a cubicle type form where you can come in and out freely, is going to be different than somebody whose office is functionally a state or governmental vehicle, and which will be different than somebody who has a private office. So each of those inquiries is going to be shaped by the issue at hand that the employer is investigating and the realities of the workplace that the employee is working in. So the question of whether an employee has a reasonable expectation of privacy is going to be and has to be addressed on a case-by-case basis on the face of the facts that are in front of the employer and then potentially later the court. Next slide, please. So the key takeaways in searches of physical workspaces is, one, that employers can search an employee's property, but two, it has to work to fit the reasonable expectation of the employer's privacy. And we need to be able to kind of craft how that expectation of privacy is met. So employers, in looking at whether or not an investigation can take place or how it can take place, the level of expectation of privacy is going to be important to have kind of an idea of ahead of time. So you want to set a standard for employees by announcing, creating policies and letting people know on the front end when they're being onboarded into an employment process or as a policy is adopted. Let your people know what your policy is on workplace searches, whether or not that's something that can happen. Obviously, you want to make sure that they know that it could happen. You want to be able to set an understanding of what is appropriate on employer-owned property, and make sure that you clearly articulate throughout an employment relationship what the expectation of privacy is. Employees, if you get to a place where you are conducting a search, we would suggest that employees be present during those so that they're aware of what's happening. You don't have any concerns about that on the back end rather. So you want to make sure that you're clearly articulating the intent from the beginning of the employment relationship, and then anytime you have to actually rely on a workplace investigation or excuse me, a workplace search, that you're involving the employee in that search by having them present if possible. So obviously we are a little bit of living through a different world than we had previously when it comes to where a physical workplace may be. And I currently am sitting in my house, in my home office, and working in a place that my employer does not normally have access to. It's a different expectation. So Leonie, if I could bring you back on, how do you think that reality of home office implicates searches and the right to privacy in the workplace?
So the search of a home office is a pretty tricky question, and you hit the nail on the head when it's what's going to change is the reasonableness of the expectation of privacy. I have a much higher expectation of privacy when I'm sitting in my home, and I think objectively, if you look at sort of general consensus and societal norms, people have a more heightened expectation of privacy when they're at their house as opposed to when you go to a work setting. So I think that the answer is tread lightly or tread slowly if you ever have a case where you think you need to search a home office. The employer as a government is going to have to meet a certain standard. They're going to have to have a reasonable suspicion for making that search because it is a government search of a home. Now, there are things that you could probably carve out as having a right to search. For example, if your employee is at home but working on a government issued computer or working on a government issued cell phone, or using government issued equipment, your ability to search or retrieve that equipment is probably going to be higher than if it's a personal computer, a personal cell phone, all of that. And when you send employees home, or if you have a work from home policy, which all of you should have, you want to spell out specifically in policy what some of those expectations are. So is there an expectation the employer will issue government issued equipment and that the government retains the right to view that equipment, to retrieve that equipment, to monitor the use of that equipment? That's going to want to be set out in policy. It's going to be a rare occasion when the government is going to be able to go in and search a home office absent sort of, government issued, sort of standard issued equipment. So it's an area, again, tread very carefully, because you are the government, that Fourth Amendment applies to you, and you need to meet the constitutional standard of when you can search, and that reasonableness and that expectation of privacy is going to be much higher when you have your employees sitting in the middle of their home, even if they're conducting work in the middle of their home. So it's not a particularly satisfying answer. Again, as you're going to hear from us over and over again today, there's going to be a fact-specific inquiry that balances, what the employer's need is for the information you're trying to receive and what the employee's expectation and the reasonableness of that expectation of privacy in their home office.
Thank you. All right, so we're gonna move now to personal searches. And so generally, this is going to be kind of the conceptual idea of searching in a physical person, the personal clothing of an employee, or personal items that the employee brings in or brings into the workplace. So as a kind of overarching concept to get going, the more invasive a search, the greater the expectation a person has for their privacy, which just logically makes sense. And this is certainly true when we're talking about a physical person. And we have this, good quote out of this Bodway case, which is an Oregon appellate case from back in 1981, just holding for the concept that rarely will circumstances justify a body search. It seems like a no-brainer, obvious point, but no one should conduct a body search without consent in the workplace. to the extent that an employer is going to engage in a personal search, whether that be of a person, clothing, personal items, it's best practice to inform the employee in advance of the extent of the search. So whether it's going to be a bag or a jacket or wherever it might be, and inform the employee that they're free to leave and not required to participate. Kind of when we're talking about with the workspace searches, a concept to keep in mind is narrow scope that is tied to the legitimate purpose of the search. So if you work in a sensitive workplace where being able to remove items from the workplace is something that needs to be considered, that can be wrapped into policies and then shared and communicated transparently so that employees are aware of that reduced expectation of privacy in that particular item. We see that a lot in private employment, but it would equally apply to a public employer where that would be at issue. Okay, next slide, please. So U.S. Mail, Postal Service, so many of us, myself, not accepted in times where you're working out of your physical workspace, may intentionally divert some of your personal mail to the employment place for the purposes of having mail security or because you are getting something delivered that is a surprise for someone else, whatever it may be. But generally speaking, mail addressed to employees that's delivered at the workplace can be opened by the employer. It would be that's going to be even more true where it's in the normal course where you have a centralized place where mail is delivered to and you have specific staff whose job it is in part to process mail and get it to the right places. It is often common for all mail to be opened by a specific employee and then dispersed therefrom. I think we're all also generally familiar with the idea, but hey, if it's not addressed to you, it's a federal crime to open someone else's mail. And it's true that federal law bears mail obstruction, but once that mail arrives at the workplace where it was addressed to, it's deemed delivered. And pursuant to the Postal Service's Domestic Mail Manual, all mail addressed to a governmental or non-governmental organization or to an individual by name or title at the address of the organization is delivered to the organization, as is similarly addressed mail for former officials, employees, contractors, agents, etc. So to that extent, if it's part of the normal course, the open mail, and it gets dispersed that way, that is not an improper search, and putting in place concepts of expectations and policies for what happens if the employee decides to have something very illogical to have delivered to the workplace delivered there. Like that's going to be up to the policies and procedures that you have there written out internally. All right, next slide, please. So we live in a technological world, and I think pretty much everybody that's attending today is probably pretty heavily reliant on email systems, communication systems, computers, cell phones, devices that are issued or supported by the employer. So this can include anywhere from pagers, which we'll get to in a second here, a little bit of a blast from the not too distant past, to using electronic filing systems. Employers are generally allowed to monitor employee activity that occurs on systems or devices that are employer owned or maintained, as long as the employer has good policies, there's good policies in place that would dispel any rights of privacy. Although not having policies in place is not going to necessarily sink the right to conduct monitoring on the workplace device. So it's the same reasonable expectation of privacy concept. So if an employer provides an email system and an employee engages in improper conduct on an employer provided and maintained email system, that employee is going to have a lowered reasonable expectation of privacy in that email on the sole basis that the email is provided by the employer. Obviously, the kind of through line on all of this is that your best practice is to have clear policies that you provide to an employee, give them an opportunity to review and ask questions about at the time that they get onboarded or at the time the policy is adopted, so that there's a clear distinction as to what is and is not employer-owned systems or devices, what is or is not being monitored, what is or is not going to provide a lower expectation of privacy in the employee. So obviously the best bet is always to have clear documentation on that. But as we'll get into as we go over another case, the concept of privacy and communication is a shifting, and I think a lot of people would maybe argue eroding area for privacy. And so that's going to be a question of reasonableness, but that will only be further enforced through policies. I think it's less and less uncommon for employees to use personal cell phones or other devices, where we're seeing sort of a graying of the difference between an employer provided and an employee owned device, or solely employee private use device. Employees, a lot of businesses, a lot of organizations now will give a stipend for a personal phone that will be also used for professional purposes. So Leanna, I'm going to have you jump in on this one too. What happens in those circumstances when it comes to privacy rights?
So, as Jess has sort of worked through the general rules around work, email, internet, computers, and phones, when it's a government issued, employer issued phone, employers are going to have more latitude about being able to access that, and in large part because employees have less of an expectation of privacy in a government issued phone. If it's a personal phone that's being used for work business, there are ways that the employer can still access that information, but you're going to have to set it up right. I will say, when we advise employers, government employers in particular, but even private employers sometimes, the best practice is if you have an employee that is going to be expected or required to use a cell phone for conducting business, the best practice is that you issue them a company phone, because then you get to retain the rights to that information. It's not commingled with stuff that people have an expectation of privacy in. For government employers, this is really important for purposes of capturing public records. If the employee is using their personal devices for transacting government business. So the best practice is going to be that you issue a government issued phone if you expect that employee to do work by phone. If it's an employee that doesn't really have a need for a cell phone, they have an office, or they just aren't expected to be available in that way, but via cell phone all the time. You should just prohibit work from your personal phone. You should say, especially as a government employer, we expect that you are not going to be transacting government business on any device other than a company issued government device. And if you do choose to conduct government business on a personal cell phone, we retain the right to access that information for purposes of responding to a subpoena, responding to a public records request, retaining public records, or to search for potential misconduct. That should be spelled out in your policies, that if employees choose to use their personal phones to conduct government business, that they essentially lose an expectation of privacy to some degree in that phone. That doesn't mean that the employer is going to be able to go through and sift through, all of the personal texts too. They may, if there's a compelling government interest to do that, but again, that's going to be a case-to-case, fact-specific scenario to see what you have access to and why. Maybe they've done a really bad job of differentiating between personal and government use, and the only way to parse out what's government use is to go through all of it. Again, but that should be spelled out in a policy that basically puts employees on notice that they are going to compromise privacy if they choose to use their personal phone. In the scenario that Jess mentioned, where employers sort of proactively allow employees to use their personal phone for government business, like a reimbursement policy, for example, that too should be spelled out in policy, that, we are providing you a reimbursement for your use of a personal cell phone for government employer business. But with that also comes an expectation that we're able to retain information, that we're able to comply with public records requests, that we're able to comply with subpoenas, that essentially the information that you create on your personal phone that is related to government business is government public record, and the employer retains a right to control that. You're going to want to have that very clear in a policy. It's not a bad practice if you're going to have that type of reimbursement policy to have a specific form that an employee fills out and signs acknowledging that they understand the limits of their privacy if they're going to use their personal phone. It's essentially an implied consent that, if I'm going to use my phone, get reimbursed by my employer, I understand that I have impliedly consented to losing at least some expectation of privacy of some of the information on that phone. So that's sort of, again, different ways that a court may look at those issues when it comes to personal cell phones. But again, I said this at the beginning, I'll say it again, best practice is that you don't have your employees using personal cell phones for government business. It makes it really hard to, retain public records, comply with public records laws, issue litigation holds, and just generally you can end up in quite a quagmire when you allow your employees to conduct business on their private phones on behalf of your government employer. A more sort of the correlated interesting question, which Jess is about to talk about, is when an employer allows an employee to use their government issued phone to also conduct personal business. And Jess is going to talk a little bit about that.
Great. Yeah. So I'm going to cover a case, another U.S. Supreme Court case. This one's from 2010. It was a City of Ontario, California versus it's the named respondent is Quam, but there was actually several members of the city's SWAT team and some recipients of text messages who are all part of the underlying proceeding as well. So it's actually a fairly reasonably sized group of people who are affected by this. So the city had issued pagers to SWAT team members, which it just makes me want to comment on pagers and their place in history. But in any case, the city issued pagers to SWAT team members and allowed those officers using them to use them for personal purposes and pay for any data overcharges. And what ended up happening over time is that a series of officers were kind of consistently having overage charges that ended up becoming the subject of an audit and ultimately the subject of this lawsuit. But the official policy that was given to the officers included a right to monitor any, quote, network activity, including email and internet use, end quote, with or without notice, and stated that the officers should have no expectation of privacy in their communications. The informal policy that was being applied by the lieutenant in charge of issuing and monitoring these pagers was that they would not examine the officers' messages as long as the officers continued to voluntarily pay for the charges that were incurred due to the excessive use. Over time, the city ended up acquiring transcripts from pager providers, who was also ended up being involved in the underlying litigation for these pagers for the officers that had repeated excessive use. And ultimately, the transcripts of the pages, unsurprisingly, showed that this officer, along with others, had been using the pagers for explicit personal purposes, including sending sexually explicit messages to wives and other women, and ended up being hundreds and hundreds of personal text messages included in the transcripts. The basic issue in this case was whether government employees had a constitutional right to keep those text messages private on government-issued pagers. Ultimately, the Supreme Court unanimously decided that the City of Ontario's audit of the text messages sent on devices that were owned by the city was reasonable and ended up rejecting any claim relating to the Fourth Amendment. Next slide, please. The Supreme Court kind of hedged a little bit and decided a very narrow issue, though, and it really was on the reasonableness of the audit itself rather than the expectation of privacy on the officers. Given the difficulty of the issue, they weren't able to completely escape incorporating some amount of analysis into what the overall process was. But in terms of the ultimate decision, the court assumed for the purposes of its review that the sergeant did have an expectation of privacy, but that the city's review was reasonable. in looking at the expectation of privacy piece, the court did go through a bit of an analysis on that, what I was talking about a little earlier, the idea that as our engagement with technology and things like the internet have expanded, it's a shifting analysis as to what the expectation of privacy is. That's obviously a bigger conversation that I think we all have, both in our personal, professional conversations from time to time, about what really is a reasonable expectation of privacy when you do things like blast your personal news on social media. But for the purposes of this case, the court acknowledged that that was going to be a challenge, but ultimately determined that the employer had a right to engage in a review and audit of transcripts in the context that was offered, which was that the chief of police was recognizing that they were repeatedly using getting overage charges on text messages, and wanted to determine, frankly, if the contract that the department had entered into was enough to meet the needs, the real needs of the department in the use of these pagers. And in conducting its audit, they only pulled a 2-month period for the officers that they reviewed. So it was a very narrow, very specific review. All right. Next slide, please. So in terms of takeaways from Quan, like not only in the context of the reasonable expectation of privacy, but also in terms of the data usage and what is laid out, it's best always for a public employer to set very clear expectations on what is expected from employees with the specific devices that are being provided or the specific systems that are available. So a starting point is always going to be to start with a review of the current policies, see what is defined as the available scope of search if needed, and have consistent messaging on privacy limitations throughout the workplace. So making known that searches may be possible and engaging in consistent messaging on privacy limitations throughout the workplace. With the City of Ontario, that was something that created an issue because the written policy was clear and appropriate, and then the individual lieutenant who was in charge of issuing the pagers was messaging differently to the individual officers, creating an inconsistent balance between the written policy and the enforcement of the policy. So that second step, have consistent enforcement of policies across the agency. So once you have that clear policy written, scope is defined, language about privacy limitations is delivered, make sure that that is actually being consistently enforced. So even if you don't need to do an audit, or it doesn't seem like you need to do an audit, don't tell people that you're just not going to, that they can get away with breaking the policy if they do this other thing, like pay for the overages. Make sure that the expectations are clear so employees have an understanding of appropriate and inappropriate use of employer technology, and give specific examples. It seems a little bit too obvious, but as in the case of Quan, you don't know what an employee will decide to do with a device, even if it seems obvious that because it's an employer provided device that could be subject to public records or any other number of searches or other avenues of disclosure, that they're just not thinking about that. So laying out in your policy prohibited use, provide some specific examples, but don't limit it to only those specific examples. And those can be as obvious as don't sext on your phone or your pager, don't engage in profane or sexually charged language, don't send offensive, harassing or demeaning memes or other things on your your employer provided devices or systems, and make sure that those policies are being reinforced through regular training, and that they're updated as we learn more about technology as it changes. All right, next slide, please. So wiretapping and recording conversations in the workplace. So this is broadly also just under pursuant to Oregon law. We have statutes that cover both wiretapping and recording conversations. As we've moved into increased use of remote technologies, this is just as important as ever, if not more so. And in fact, my computer right now is saying to me, caution sign, recording has started. This meeting is being recorded. By joining, you are giving consent for this meeting to be recorded. That would likely comply with Oregon state law. So Oregon statutory scheme has kind of created two different avenues. The first is if you're on a telephone call, and this has been adapted functionally to include video calls, although the statute hasn't been updated to explicitly pull that in. And then when there's a face-to-face conversation, when you're in person with somebody. So with a video or a telephone call, so that would be more on the wiretapping side, that requires consent of at least one participant, which is a little bit of a catch, because if there are two people on a phone call and one person can consent by hitting the record button, and that would likely be enough to comply. On the flip side, there's the face-to-face conversations, which is the idea that you would be able to see what's happening. But the goal there is to make sure that both people are aware that a conversation is being recorded. It doesn't necessarily require consent, but it requires that all participants to the conversation are informed that it's happening. So that may be functionally pulling out a recording device, putting it in the middle of the table and hitting the record button. But ultimately, there is a distinction between the two. And it makes some amount of sense, since in face-to-face, you're in the same environment, telephone, video call, people could be doing things that you're unaware of. But these laws do have exceptions in specific settings. So and those are all laid out in various statutes that we have on the books here, but they include correctional settings, law enforcement settings, including interviews, but also in the furtherance of official duties. Public meetings and hearings and classroom instructions are the main ones that come to light. All right, next slide, please. So video surveillance and GPS tracking, these are going to be things where you're still going to want to use that kind of the reasonable scope tied to the needs of the organization. Video surveillance can occur with or without audio recording, as long as there's at least visual recording. Your best bet is always going to be to post notices and signs, give warnings to employees and the public that there's video monitoring happening. In the workplace, this is something that you would want to incorporate into policies, as you would with all of these other topics that we've talked about, just to give employees awareness that some of the premises may be monitored with video recording. Ultimately, you want to keep it narrow as needed, so don't exceed that reasonable scope, because that's always going to be your starting place on any case-by-case review. So thinking about areas where the workplace may have heightened interest in security, either because there's valuables on site, or because there are, like if let's say there's a lot that has state vehicles parked on it, it would be totally appropriate to have video monitoring of ingress and egress of that location, probably an office where there are keys, any type of increased security needs, but just making sure that you've got that signage, both internally for your internal facing employees, external facing public, and then make sure that you have the clear written policy based on appropriate and reasonable monitoring, and to maintain a harassment-free workplace, and just keep those updated, review your policies and make sure that they are current with what your actual workplace realities are. All right. I'm now going to turn it back over to Leonie to talk about social media and other interests.
Great, thanks. So we're going to spend some time talking about social media use, because this is an issue that comes up a lot, and it comes up in a couple different contexts. First is, can employers control what employees post on personal social media? And sort of the flip side to that is, can employers discipline employees for things that they post on social media? The other sort of place where this might come up, which is more related to the privacy aspect that we've been talking about is, can employers view an employee's personal social media, and to what extent are they allowed to monitor and view an employee's social media? So that's sort of on the privacy side. When we're looking at whether or not employers control what employees post, or whether or not they can discipline employees for things that they post on personal social media, that's getting into more First Amendment free speech protections. And so we're going to pivot for a little bit just to do some refreshers on free speech in the First Amendment. So under the First Amendment, as a government employer, again, this relates to you, it would not apply the same to private employers or private employee settings. So, but as a government employer, the First Amendment provides your employees with protections for their speech, which would include the use of social media. So again, like the Fourth Amendment, though, it's not completely unrestricted. The employees don't have completely unfettered free speech rights. There has been a lot of cases throughout the years by the U.S. Supreme Court that have sort of carved out what that free speech means. And it's not unrestricted. Employers do have some ability to control speech of their employees, or to take action against employees for speech that they engage in. This is a fairly complicated topic, and typically we would walk through this in an hour, through it in a few minutes. So, obviously, please, if there are questions, post them in the chat, or we're happy to follow up. But as sort of a summary of First Amendment analysis, the first thing that has sort of been fleshed out in case law is the First Amendment is going to look at whether or not an employee was speaking pursuant to his or her official duties or as a private citizen. If the employee was speaking pursuant to his or her official duties on behalf of an employer, it's not First Amendment protected. An employer can take issue or take discipline for speech that employees engage in their official duties as a government employee. It's only if the employee is speaking as a private citizen that the First Amendment might be implicated. So the first question you're going to ask is whether or not the speech that you're looking at that's problematic, that you might want to take some kind of action against, did it fall within the employee's specific job responsibilities? Was it pursuant to official duties, or was it as a private citizen? There's no real bright line. They're going to look at different factors, but some things are fairly obvious. So if the speech is your press person, your press secretary, and they are giving press comments in their role as the press liaison, that's obviously going to be speech pursuant to official job duties. If the person who is speaking is saying, I am representing X district and here's what I have to say, that obviously is going to be found to be pursuant to official job duties. Typically speech that's sort of internal to the workplace, talking about things to a supervisor, things that are sort of specific to the employee's employment situation or learned through employment, oftentimes those are going to be found pursuant to official job duties. Private citizen speech is going to be more typically speech that's made outside of the workplace, speech that's made on personal social media, which is, why it's so important to talk about right now. If you are going out to the local news and expressing opinions on things without representing, this is the official position of, X district, that might be speech that's made pursuant to a private citizen. And so that's the first analysis you're going to have to go through, is determine whether or not you think the speech was made as a private citizen or pursuant to official duties. And start with the job description. Start and see if the speech that is at issue falls into any of the job duties that this employee would be sort of expected to perform in the course of their job. Assuming that it's a private citizen, that you've determined that the speech was made pursuant to a private citizen, you're going to go on to the next step, which is, if the employee was speaking as a private citizen, does the speech in question address a matter of private interest or a matter of public concern? If it's considered private interest speech, then there's no First Amendment protection and the employer can take action or discipline. You don't have to worry about First Amendment implications. But if it's speech that is on a matter of public concern, then you're still sort of within that First Amendment analysis. You have to go on to the next step. But in looking at what might constitute a private interest versus a matter of public concern, internal disagreements about my own employment situation, about my supervisor, my disputes with others in the workplace, those typically those grievances that are about me and my situation are not typically going to be found to be matters of public concern. Those are private interests. I'm raising issues about me, about my employment, about my supervisor, things that I have an issue with. Things that would more typically be matters of public concern are questions around, allocation of the district's budget, sexual harassment or discrimination by district employees or officials, union advocacy for improved working conditions, if I'm unhappy or unsatisfied with the district's response to and plan for the handling of the COVID pandemic. Those are types of things that will probably more likely than not be found to be matters of public concern. And so once you've determined that the speech is a matter of public concern, then you have to proceed to the next step. However, if you determine that it's just private interest speech, then there's no First Amendment implication. You can go ahead and discipline or address the speech without going further in the analysis. The next step is the analysis, and some of this language is going to be a little bit familiar. So we're going to be balancing interests between the employer's interest in maintaining sort of the integrity of the workplace versus the employee's interest in the speech. So the third step is that if the speech addresses a matter of public concern, is it a reasonable conclusion that the speech will substantially interfere with the official responsibilities of the office? If the answer is yes, then the analysis is over. The employer has met its burden to sort of show that the speech in question, even though it was made by a private citizen on a matter of public concern, is substantially interfering or could substantially interfere with basically the ability of the government entity to do its job. Then you can take action. If the answer is no, though, if there's no burden to the office, if there's no risk to the work of the office, then the employee's speech is going to be constitutionally protected. You talk about the balancing of the government's interest, and it's going to be on the employer to, sort of meet the burden that the balance tips in your favor. The different types of factors that are going to be considered are, how valuable is the speech? What was the employee's intent in speaking? The time, place, and manner of the speech, whether the speech caused the employer to be concerned about problems in the workplace. Those types of problems could include disharmony among coworkers, disruption to the office, impaired performance of job responsibilities, undermining the authority of the employer, or destroying close working relationships or compromising working relationships with district partners. So those are the types of things that you're going to be looking at to determine whether or not that burden has been, sort of the employer's sort of needs to be able to articulate that it is a reasonable conclusion that the speech will substantially interfere with the official responsibilities of the office. And so as you're going through the analysis, you're going to want to take note and document the different types of factors that you're considering to conclude that you think there's going to be disruption to the operations of the employer. Again, as we've sort of noted over and over again, this is going to be a fact-specific inquiry that balances the interests, and there's really no blanket rule that X speech is going to be protected versus Y speech isn't, because time, place, and manner may make a difference. Intent may make a difference. So there's just lots of different factors that need to be looked at in determining whether or not the speech is protected or not. A question we get a lot is around hate speech, like when and why could hate speech ever be protected, which is a fair question. But the answer is the sort of the same analysis. It's going to be a fact-specific inquiry. Oftentimes it's going to fail some of those factors, right? It may be found not to be a matter of public concern. If you have an employee that's just spewing hate, that might not be found to be a matter of a public concern. And in the employer's interest in sort of that disruption to the workplace, and oftentimes in a hate speech analysis, may outweigh the employee's right to speech, even if it's speech they're making in sort of their private, citizen capacity. It's more likely to weigh in the employer's favor if the topic of the speech implicates, sort of directly, if it's anti, constituents, if it somehow hinders the public body from fulfilling its mission. Speech that adds value to a discussion. So if it's more, there's a fine line, I think, between debate and hate speech. But, if it's more debate type speech that's, trying to add value to a controversial discussion, may be more likely to be protected than speech that is merely, just displaying hateful or harassing points of view towards a particular group. But again, you're just going to have to go through that entire analysis if you have an employee that's posting what you consider to be hate speech on their social media to determine what you can do about it. So one of the questions we get is that, whether or not employers can have policies that, either restrict the use of social media or, take action against employees for their social media use. The answer is yes. You're going to want to have a policy. You can't just restrict employees from using social media, and you can't sort of restrict speech broadly. You're really going to want to focus on the impact of the speech on the operations of the employer, and it should never focus on the content of the speech. So, you're going to be having policies that may put employees on notice that speech that impairs harmony among employees, has detrimental impacts on close working relationships, or interferes with the district's business. That's the type of speech that may be subject to discipline up to and including termination. But you're going to want to have a policy that really is content neutral, but puts employees on notice that if their speech sort of disrupts the office, that might be something that the employer might take action about. Sort of stepping back into sort of the privacy arena, one of the questions we get a lot is whether or not employers can monitor the use of social media. The sort of short answer is yes, and we're going to say, but there's a bunch of things you should be aware of, right? So, employers can retain the rights to monitor and search their employees' use of social media, but you should put employees on notice that you may do so. Clear and explicit policies that says, that the employer retains the right to monitor social media. There's going to be limits on this, which I'll get to in a minute. So putting them on notice through your policies, and uniform enforcement is really important. You can't just sort of pick and choose which employees' social media you're going to monitor. So for example, if an employer is searching social media of employees that they know have been out protesting, whatever side they're protesting on, that can start looking discriminatory if you're singling out a group of people that are arguably out exercising their free speech rights, that you're sort of subjecting them to heightened scrutiny through monitoring of social media. You need to be uniform and consistent around when you're going to be looking at employees' social media. You can put in policy, I said you can't restrict content of speech on social media, but you can restrict some things. So you could say you can restrict them from using confidential information that they gain from their place of employment. You can restrict them from making postings that purport to represent the district's viewpoint when they don't have the authority to do so. You can prohibit them from using, the district logo for, their personal social media. So there are some ways that you can restrict things that go on in employees' social media. But you can't say you can't talk about these topics unless they sort of fall into these narrow exceptions. Again, the policy is there so that employees are on notice of what is acceptable and what is not acceptable. Jess talked earlier about the policies around, what is acceptable use of your cell phones and your pagers. Don't sext and don't, send explicitly graphic information. Social media policy should be similar. It should have some, explicit notice to employees about what types of things are prohibited. But again, this is any time that you're putting a policy in place that's sort of restricting an employee's constitutional right to anything, in this case, speech, you should tread lightly, make sure that you're consulting with counsel and that you have a policy that's crafted, as narrowly as possible so that you don't subject yourself to First Amendment challenges. I noted earlier that there were limits to monitoring social media. The Oregon legislature in particular has enacted a statute that prohibits employers from requiring or requesting access to passwords to employees or applicants' personal social media accounts. So while employers are able to monitor sort of publicly available information on social media, they are prohibited from requesting or requiring employees to give them passwords so they can sort of access private material. You cannot require or request that an employee add their employer to their list of contacts. This is something that you want your supervisors to be aware of so that you don't have supervisors trying to add their subordinate employees on Facebook. Employers are prohibited from requiring employees or applicants from maintaining social media accounts or from requiring employees to advertise on behalf of the employer or the district on their own personal social media accounts. So just be aware that there's those specific restrictions in state law. Just a comment on social media and labor concerns. So Oregon has recently enacted some fairly protective measures of employees that are engaging in union activities. So you're going to want to be aware of new rules that, allow employees, paid time to conduct union business, access to bargaining unit employees' contact information, and use of the employer's email systems for purposes of labor activity. And you want to be careful of restricting or punishing any speech on social media or elsewhere that might fall into the protections for employees engaging in concerted activity. That's just an area where you're bound to draw an unlawful labor practice charge. And again, you're going to want to avoid monitoring and interfering with social media activities as it relates to unions and organizing as not being an unlawful labor practice. Just a quick moment on social media and pre-employment screening. So this is looking at the social media of your applicants. Employers may and do publicly review available social media, the public facing stuff, so on a candidate's LinkedIn or a public page of the Facebook or Twitter, employers can do that. But, again, we're going to proceed with caution because one, the employer may learn information that you really have no business knowing about an applicant. So, for example, you might learn that they are in a same-sex or interracial relationship. You may learn that they have children or they don't have children. You may learn that, the applicant has a disability. This is information that employers really shouldn't have as they're going through the application process. So if you choose to look at somebody's social media, you may have that information and you can't unsee it. And if an applicant later on, claims that they were discriminated against because they have a disability, you're going to have to say the employer knew that the employee had a disability because they found out through their Facebook page. You also just want to watch the consistency. You should, if you're going to check social media, you should check for all applicants, not just some. And you should also be mindful that relying on social media or professional networks may have a disparate impact. For example, only 5% of LinkedIn users are African American and only 2% are Hispanic. So when you're using social media to vet candidates, there's going to be a bunch of candidates that you can find and a bunch of candidates that you can't. And if that is impacting your analysis and whether or not you want to offer somebody a job by the quality of their social media, that might have a disparate impact on certain groups. Okay, we're going to move away from social media and just talk about some other areas where privacy and confidentiality are implicated. So alcohol and drug testing. So employers should, they can and they should have a policy that prohibits employees from being under the influence of alcohol and drugs at work. That policy should provide notice that employees may be subjected to testing if they are suspected of being intoxicated by alcohol and drugs at work, and that they may be disciplined for refusing a test. So, assuming that you have that policy in place, as you should, if you have an employee that you believe is intoxicated or drug affected at work, you're going to want to observe and document those observations. First, ask if the employee is going to consent to the test. If they refuse consent, follow your policy. Your policy hopefully will say employees may be subjected to testing if they're suspected of intoxication or potential discharge or discipline for refusing a test. So follow your policy to the letter. Some questions we get are about marijuana because it's technically legal under state law, but illegal under federal law. That was enacted in ballot measure 91. It doesn't allow the use of marijuana, even though marijuana may be legal. It doesn't allow the use of marijuana in public or while driving. And you still have a right to make sure that your employees are not impaired by alcohol, which is also legal, or marijuana, which is legal under state law, that they are not impaired at work. So just follow that same analysis about whether or not you need to, you have a suspicion of somebody being under the influence at work. The law has specifically stated that, the legalization of marijuana is not going to impact other state or federal employment matters. And the Oregon courts in particular have said that employers don't need to accommodate the use of medical marijuana. So we do have some direction there. Investigating misconduct, workplace harassment, we put this in here because oftentimes the harassment or misconduct may have taken place off work. And, employees feel like they have a privacy in what happens off work. The takeaway is that, yes, employers can investigate and or discipline employees for off-duty conduct, but you need to show basically that there's a nexus to the workplace. You also need to have policies that puts people on notice that certain off-duty conduct that does have that nexus to the workplace may be subjected to discipline up to and including termination, and the employer needs to have a process to promptly, thoroughly, and impartially investigate those types of alleged misconduct and complaints. The key here is going to be the sort of the nexus to the workplace. So, for example, if a police officer provides false testimony in a personal divorce proceeding, even though it was off work, there's going to be a fairly significant impact to the officer's ability to do their job. So it's that kind of analysis. Like, is the off-duty conduct going to impact the employee's ability to do this job? And again, that's going to be a bit of a fact-intensive, by case scenario and analysis. But again, you can get into off-duty conduct for those purposes. I mentioned earlier that there is a difference between privacy and confidentiality. They're not synonymous, but there is some overlap. We're mainly talking about information that the employer may come in contact with that is sort of held to be confidential. And so some of the different types of laws might include, specific laws that protect Social Security numbers, medical information. The Oregon Public Records Act sets some expectations for different types of material that's going to be held private. We're going to go through some of these. So, for example, Social Security numbers are specifically spelled out in state law that, they're prohibited from being printed, displayed, or posted. Some practice that employers have, and I hope that all employers stop, is that they use the Social Security number as an employee identification number. They should not have an employee identification number that is the same as their Social Security number. You should have something different. So make sure that you have strict protocols for any records that would have Social Security numbers on it, like I-9 records or Social Security payroll records. We're not going to talk about all of the public records, but just understand that the state has carved out some expectations that certain types of records may be kept confidential. A personnel discipline action or materials documenting or supporting that action may be confidential, except in this particular conditionally exempt public records exception, there's that balancing test of whether or not there's sort of an outweighing of the confidentiality privacy issues with the public's right to know. So the exemptions that you would typically find in ORS 192.345 are the conditionally exempt exemptions, where you're going to have an expectation of sort of confidentiality to begin with, but that's going to have to be balanced against the public's right to know. The public records exemptions in 192.355 are considered exempt. And so they actually are records that will remain confidential. It's been said under state law, these are going to be confidential records. But even then, like the 2A, the first one on there, there's also a balancing test, in that particular exemption that talks about if there's a public interest by clear and convincing evidence that requires disclosure, it may still get disclosed. So just as public entities, you're going to want to be aware of what types of records might be subjected to public records exemptions so that you're not inadvertently releasing records where the legislature has said, these records are exempt from disclosure. I'm going to turn it over now to Jess, who's going to close us out talking about some data privacy, medical records, and criminal records.
Great, thank you. As our time is coming to a close, I'm going to try to move through this with some speed, but hopefully not glossing over things too much here. So I'm going to start with the data breach law. So Oregon has statutory requirements in terms of data breach. That's obviously something that we're becoming increasingly aware of happening. And the main point to know is that employers may have liability for data breaches that implicate employee records. So any employer that owns, maintains, or possesses personal data in the course of his or her business or volunteer work must give notice of any data breach to any Oregon consumer whose personal data was breached. This requires that those entities develop, implement, and maintain reasonable safeguards to protect the security, confidentiality, and integrity of the personal information. When a data breach occurs, the entity must give notice in the, quote, most expeditious manner possible, but generally speaking, it must be done no later than 45 days after the data breach. Notice can be given kind of effectively through a major statewide television and newspaper media, or otherwise through direct contact with the people affected. Next slide, please. So in terms of what to do in the case of a data breach, starting point is you have to take proactive steps to safeguard employee and any consumer or customer data. The security measures should be integrated into your document retention policy, and then have a regular review and update cycle, making sure that you're up to date with your current systems and practices. If you end up having a data breach, address it quickly and expeditiously, because bad news certainly doesn't get better over time, as we've seen with so many of these entities that have suffered major data breaches. So in terms of ways to try to avoid or react to data breaches, we're going to talk about 3 categories of safeguards pretty quickly and generally. The first is administrative, then the technical side, and then finally physical. So under the administrative side, start by designating 1 or more employees to coordinate a security program for your organization. Engage in regular risk assessments for your systems, and then take steps to reduce any identified risks that are made through the course of those assessments, and use security services and programs to help your organization in dealing with your data and protecting against any untoward breaches. You're going to want to adjust those programs in light of any changes to your organization over time. Obviously, technology is increasing and changing on a regular basis, and so are the people who are trying to engage in bad activities. So we want to be kind of vigilant on making sure that we're addressing these through our administrative process, and then also through our technical safeguards, which is just making sure that we have the systems and programs in place to make sure that we are shoring up our resources as best as possible, assessing our risks and vulnerabilities, and then adjusting to them as we need to. Engaging in active monitoring and detecting work will help prevent and respond to any attacks or system failures that might occur. You're going to want to engage in regular testing and monitoring activities, get those good third-party resources, get those good programs in place. It's a robust market at this point. And then physical safeguards, we wanted to just make sure that the systems are in place to assess our risk, make sure that we have the understanding of our information collection, storage, usage, retention, and access to our data, as well as processes for disposing and implementing any reasonable methods to remedy or mitigate any risks that have been identified. That goes back to that monitor, detect, prevent, and isolate type of concept. And that will help protect the organization against any unauthorized use of personal information. And then when something has ended its useful life, make sure that you have a system in place to dispose of all personal information that you may have, whether it's employee or external facing consumers. Make sure that it's a complete process. So if you keep paper records, have your document retention policy, but when you get to the end of that, make sure that you are disposing of them properly. I have a list here that I will read because I think it's funny. Burning, but also effective. Burning, pulverizing, shredding, or modifying a physical record so it no longer has utility. And if it's an electronic record, make sure that it's destroyed or erased from electronic media to the point that it can't be reconstructed or read after the fact. All right, next slide, please. So I'm going to switch quickly to confidentiality and privacy of medical information. Employers should keep all information collected from employees about their disabilities and need for accommodations confidential. Employees are never required to disclose their disability or medical records to clients or employers. And employees who are not involved, to anyone who's not involved in the management or oversight of an accommodation process, should they have a disability. That's pursuant to Title I of the ADA, which requires that employers collect information obtained regarding an applicant or employee's medical record or medical history on separate forms and maintained in separate medical files, and to treat that information as confidential medical records. This protection covers applicants and employees, regardless of whether or not they're qualified individuals with a disability pursuant to the ADA or to state disability law. Employers have to maintain those records in a separate medical history and treat it as confidential. You can have a maintained standalone file that's locked. All right, so who might need to know about medical history? It's going to be a very limited group of people. The EEOC recognizes a few exceptions, but generally speaking, it's human resources personnel are entitled to know medical information, especially if they're the ones who are helping with any accommodation or interactive process. Under the EEOC exceptions, there's also supervisors or managers that might need to be informed about the necessary restrictions to the employee's work or duties pursuant to any accommodations. In those cases, the employer should check with the employee first before sharing any medical information with the supervisor and explain why that might need to happen. So an example where that might come up is if an employee has a seizure disorder and needs accommodations in their workplace relating to what to do in the event that the employee has a seizure during working time. The supervisor would probably need to know what was going on ahead of time so that they would be able to help assist the employee and implement any plan of action. A lot of other cases, you're not going to need to know anything about the disability or anything specific about the employee's medical condition to be able to implement an accommodation. Like it's pretty easy to change schedules or a job restructure or do some sort of modifications or additional breaks without actually knowing what the underlying basis was, just knowing that there was an accommodation that you were assisting in implementing. Another exception is for first aid and safety personnel who might need to know when they're arriving if an employee is having a medical emergency so that they can be informed on specific procedures that they might need to provide. Otherwise, the employee consent should always be granted anytime you're seeking to share information, and that should only happen in specific needed incidents. Other carve-outs for need to know under medical is if there are government officials investigating compliance issues under the ADA or other state or federal laws relating to discrimination on the basis of disability. Relevant workers' compensation offices or second injury funds might need to know pursuant to state workers' compensation laws. And sometimes insurance companies need to know in the event that they need to do a medical examination in support of providing health or life insurance for employees. So pretty limited categories. All right, so that's a speed round on that. Next, we're going to quickly cover criminal background checks. So this is obviously an area where there's increasing scrutiny about processes that are seeking information about employment criminal background checks. We're also going to talk about a couple of other areas that are statutorily protected in Oregon, but the criminal background check area has really limited down, and we really have to be thoughtful about when we're looking into criminal background checks and why. So looking at the factors of if it's a job-related need to know consistent with business necessity. So it might be something that is requiring information to support an employee who is being hired to work with funds, or oftentimes teachers or law enforcement might be required to undergo some amount of criminal background check. These are intended to be narrow and targeted based on the needs of the work and the job duties. So you want to look at the nature and severity of the offense, the length of time since the crime was committed, and how that crime would actually relate to the job, and steer clear of anything that's unnecessary. These are going to be covered by Oregon statute, and Portland also has a Sydney ordinance specifically relating to criminal background checks. Great picture. So Oregon's banned the box law. The state statute applies to all employers except for those required by federal, state, or local law to consider an applicant's criminal history, law enforcement agencies, those working inside criminal justice, and those seeking non-employee volunteers. Ban the box law generally prohibits employers from excluding an applicant solely because of a past criminal conviction. Employers generally cannot require such disclosure on applications. It requires prohibits employers from requiring an applicant to disclose criminal background check on an employment application or prior to an initial interview, or in the event that no interview is given prior to a conditional offer of employment. Again, this is the state statute. Employers can still inquire about criminal history during an interview. So you're going to really want to limit when you review criminal history. It cannot be a basis used for hiring. But you can still use criminal background checks as part of the employment application process. You just can't include questions regarding criminal history on an employment application or inquire into their criminal history as part of the interview process. Now, Portland's ordinance is actually it's more restrictive than Oregon's state statute. It applies to any employer who has 6 or more employees, and it prohibits questions about criminal history during the job interview or at any point during the process before a conditional job offer is made. So employers cannot inquire about or even access an applicant's criminal history from any source before making a conditional offer of employment. So kind of going back to that social media piece, if you have access to ways of conducting these background checks beforehand, that's off the table until a conditional offer of employment has been made under Portland's ordinance. Okay, background check, records retention. So as with other sensitive records, any documentation regarding an applicant or employee's criminal history should be kept in a record separate from the general employee personnel records. So you don't want to intermingle that with onboarding paperwork. You don't want to, so you want to keep that in a separate file as you would with medical or other confidential documentation. Okay. The ban the box law has been around for a little bit, but if you haven't done an audit to see what's kept in personnel files, it might be good to take a look and separate out any of those documentation. I know for years it was pretty normal to have just to check the box yes or no, the ban the box boxes, whether or not somebody had a criminal background. So if somebody's been employed for a long time, it's possible that would be on their application and you'd want to separate that out. Okay, so credit checks. Under Oregon statute, it's a prohibition for employers to run credit checks with limited exceptions. So law enforcement, federally chartered banks and credit unions, anyone who's required as a condition of their employment to be bonded or insured, or instances where it's substantially job related for the employee to have access to financial information beyond that in a routine retail transaction, or like I would say even baseline clerical, employee credit checks are now prohibited. And you also, if you are in a situation where you can run a credit check, you still want to be thoughtful about not any running up against the implication of the FCRA in relation to credit checks and background checks for employees or applicants. If you're going to do a credit check, do a prior notification, get written consent. That will help bridge any potential issues, although not necessarily negate them. And then background checks that include credit information, again, confidential information. You want to keep that separate from the employee's personnel records so it's not intermixed with the other general employment information. And that was my speed round on background checks.
Thanks. Well, if we didn't get to your questions in the chat, feel free to reach out afterwards. Otherwise, it's been a pleasure being able to present at the SDAO conference, and we thank everybody for attending.